Okay, it's 9 o'clock. Welcome to another session of oral argument by Zoom at the 5th DCA. I'm Brian Lambert. I'm the presiding judge on our oral arguments this morning. With me on the panel today are Judges Jay Cohen and Judge Meredith Sasso. We have one case this morning. It's 21-289 Betty Ayton, Ayton versus Orange County Sheriff's Department. We are being streamed, so please keep that in mind when you make your presentations. Also, if you have any devices on any electronic devices, please either mute those or turn those off so you don't interfere with the argument. Each side will have 20 minutes. Appellant, well, you see the clock on there. The appellant will have 5 minutes for a rebuttal unless, Mr. Gurley, you tell me some other time that you would like for the rebuttal, and we'll adjust the clock accordingly. That said, if the council are ready to proceed, Mr. Gurley, go ahead, sir.
Yeah, good morning, Your Honor. May it please the court. The appellant has brought this appeal because we believe that the court committed reversible error as it relates to 4 issues. One, that the court overruled the objections as it relates to the defendant's racially motivated peremptory challenges. 2, the court erred in terms of not granting mistrial. 3, the court erred in terms of not granting the motion to interview a juror Fortin. And then 4, and these are, of course, 3 and 4 are closely related. The court erred in denying the appellant's motion for a new trial. I want to talk about them one at a time. I'm not going to read from my brief because I'm sure the court has read and know both sides of the argument. I would simply say that at the time of trial during voir dire, it was observed that every peremptory challenge, for the most part, that was made by a defendant was raised against a person of color, particularly African Americans. Ms. Ayton is African American. The deceased, obviously, her son, Kenneth Ayton, is African American. This is a case involving a young man who was shot and killed in a parking lot, and I believe it was a Publix parking lot on the east side of Orlando, related to a low-level drug deal. And the facts are that there was a...
Can you address Appellee's argument that this argument was not preserved for appeal?
Yes, Your Honor, I can. And I went back and I looked at the record and I didn't see where I did that final objection for the record, but I can tell the court this, and I don't have any specific recollection at this moment, Your Honor, candidly, but it was my practice, obviously, not to make objections in the presence of the venire panel or the jury before it was seated, so I would make a continuing objection. I don't recall specifically whether it was done in this case, Judge, but I just can say to this court today that it was my regular practice to do that, to just make the continuing objection up front. Okay, so may I continue, Your Honor?
Yes.
Okay, thank you, ma'am. Thank you, Your Honor. So basically, the idea was that there are many cases, Batson, Slappy, that stand for the proposition, obviously, that you cannot challenge a potential juror on the basis of race, because of course that denies both that potential juror as well as the party a constitutional right to a jury of his or her peers. So I don't need to argue that or to go into that. I think it stands forward in terms of what's in the record, that timely objections were made. We identified the race of the part of the plaintiff. We identified the race of the person that was being challenged. But ultimately, the court decided that there was a racially neutral reason for the challenge. We don't feel that that reason was sufficient. So we think that that was error. Okay. Now, to me, perhaps the most salient issue is the second issue that was raised, Your Honors, and that is that just prior to the commencement of actual presentation of evidence, there was a pretrial discussion in which appellant raised the concerns about the deceased criminal status, and specifically being on probation, that would be unfairly prejudicial, both in terms of 404 and 403. The court made a pretrial ruling that it would not be discussed, that it would not be raised, that it would not be brought up. However, with the cross-examination of the first witness, I believe his name is Tony Rodriguez, the record states what the witness's name was. This was the first question that opposing counsel raised: was he on probation? The appellant made a timely objection. The court directed the jury out, obviously, so that this matter could be discussed. After some short discussion and argument, the court decided that it would give the appellant two options. Option one was to give a curative instruction. Option two was to declare a mistrial.
Oh, I see that argument in your brief, but as aptly noted, there's not a transcript reflecting that conversation. What is your response to Appley's argument?
I was taken aback by that. I thought that we did order portions of the transcript. I know that conversation did in fact happen. I know that it is in fact recorded in the record. So if it's not there, and I did go back and look for it, and the only thing that I saw that captured it, that it was a discussion about there was an Ortiz motion made, and that's cited to in the court notes. But the actual portion of the transcript that captures the conversation word for word it doesn't appear to be there, but there is an actual written record of that, Judge. So in terms of that, I just think that once the appellant conferred with family members and looked at what was said, this case is tinged with race. It's tinged with a lot of things. The worst thing that could happen is for the jury to have this additional information that casts the deceased in the most negative light. These cases, when all things happen according to the rule and according to the court's pretrial decisions, in the best case, they're near impossible to prove. With this additional weight that was added, it pretty much, and we've argued, and it vitiated any opportunity, any chance that the appellant would have a fair trial. So the court gave the plaintiff, or gave the appellant, two options. We, following the instructions and the directions of the court, chose option two, mistrial, but the court, and we understand that it's in the sound discretion of the court to decide whether or not it's going to grant a mistrial. I understand the law, but I think under the circumstances, this was a case where a mistrial should have been declared. So that's the argument that we make with respect to that, Judge. With respect to the jury member, Ms. Fortune, who did not disclose that she had prior litigation, I think, and I know that portion is clearly in the record, where both parties, and I would say even the judge, went to great lengths to talk about the importance of all Venari members being honest and being transparent in terms of what their experiences were, so that we could get out the bias. And then I think the record is clear that I went even further to talk about what a defendant is, what a plaintiff is, to try to understand who's there and who to exercise peremptory challenges against and who not to. And in the presence of all of that clarity and stressing the importance of disclosing, this particular juror did not disclose that she'd had at least 3 or 4 lawsuits in which she was the defendant. And that's particularly concerning because in this particular case, the appellant was the plaintiff. So we felt like there was enough there at least to inquire, to be able to inquire with this particular juror in terms of why she did not disclose this. Misconduct, as De La Rosa and a few other cases cited to stand for the proposition that it doesn't really, that person doesn't have to have any malicious intent. Desire to deceive is not necessarily something that is determinative here, but in this case, whatever the case was, she ended up being on the petite jury, and of course it was a unanimous verdict for the defendant. So we feel that there was a basis for doing the interview, and obviously there was harm to the appellant.
Was your motion to interview the juror sworn to?
Was it sworn to, Judge?
And doesn't it have to be for an interview to be a post-trial interview to be considered?
I believe that it does, and I'm not, as I sit here again, Judge, obviously it's been 3 years. I can't tell you at this moment whether or not it was sworn to or not.
Well, it's a written motion, right? You filed a written motion?
Yeah, yes, I did, Judge.
Okay,
Meaning
so
in terms of just the actual motion as opposed to an affidavit in support of the motion.
Well, whatever document you filed to ask the trial judge for the post-trial juror interview, that has to be sworn to, whether it's just the motion that's sworn to or the motion with a sworn affidavit. I mean, do you agree with that?
I would agree.
And if it's not sworn, does that then could kind of defeat your argument as to the issue about the trial court erred in not granting the juror interview?
Well, Judge, respectfully, Your Honors, I think that the goal
I'm looking at a
of the
Supreme
court's,
Court case. Juror interviews are not permissible unless the moving party has made sworn allegations. Whitten versus State.
yes, Judge, I'm not disputing the law.
Okay. So if your motion's not sworn, then that's problematic for you on this issue. Would you agree?
I would agree as the current state of the law sits, Judge.
Okay.
So can I
Well,
then?
the current state of the law is from the Supreme Court, and we don't have that ability to change that. That's up to them.
Yes, I respectfully understand what the
Okay.
court is saying here, clearly. But my additional argument or additional thought concerning that is that the overall objective of the court system in terms of its existence is to do what is just and to do what is right and to do what is fair. So to the extent that the motion did not comply with, and I'm not disputing that is the clear state of the law, that should not ultimately, in terms of the pursuit of justice, be a bar to otherwise achieving a just outcome.
But that negates that argument. I mean, you can't just say, I mean, we all understand that we seek justice here, but I mean, there are certain rules to obtain that here. And the Supreme Court says this is the rule and you don't comply with the rule. We can't just say, well, okay, but that's not fair, so we're going to ignore what the Supreme Court's.
No, judges, I'm not at this point making an argument for this court to ignore the rule.
Okay.
I'm saying to this court and maybe to a court above that maybe that whole approach needs to be revisited, so that the ends of justice may be met.
Okay. Go ahead.
Well, judges, I don't really have any further argument that I'm going to offer at this point.
Okay, you have
I would just
650.
reserve any
All
right.
right, 649 for rebuttal. All right, very well, Mr. Gurley. All right, Mr. Palmer, if you're ready, go ahead, sir. You got to unmute yourself. Mr. Palmer, there you go.
Good morning, may it please the court. This is Bobby Palmer for the appellee Sheriff Department. I'll just speak for a few moments about the facts since appellant's counsel did address the facts. And this case has a long litigation history. It began in the United States District Court back in 2010, based upon the exact same facts that were addressed by the trial court in Orange County as well as the jury back in 2010 when the case was first filed in the U.S. District Court for the Middle District of Florida. Ultimately, the court dismissed all federal charges, and at that point, the case came back down to the Orange County Circuit Court for consideration. With regard to the facts, I'll just briefly say that this case arises out of the fatal shooting of Kenneth Ayton Jr. by deputies of the Orange County Sheriff's Office on June 17th, 2009. And at the time of this shooting, deputies were attempting to arrest Ayton after undercover deputies purchased cocaine from him with the use of a confidential informant. Once the undercover drug buy was made, Ayton accelerated his vehicle in an attempt to escape and struck one of the deputies' vehicles. Deputies ultimately were able to block Ayton's vehicle with their vehicles, but Ayton attempted to break away from the deputies' vehicles by ramming his vehicle forward and in reverse, thereby spinning and smoking his tires, all the while ignoring commands to stop and ignoring commands to put up his hands. Deputies pleaded for Ayton to raise his hands, but he did not. Instead, he dropped his right hand to his waistband, resulting in deputies firing at him for fear he was reaching for a weapon. At no time did any of the deputies observe Ayton raise his hands in order to surrender before he was shot. We're here today on an appeal by the appellant relating to two post-trial motions filed with the trial court. One was the motion to interview the juror, and the other was the motion for new trial because of alleged juror misconduct. The appellant's two post-trial motions, both related to the alleged juror misconduct on the part of a juror named Joan Fortin and her alleged failure to provide information during voir dire about her alleged involvement in 3 county court cases, which took place in 2007, 2009, and 2014, regarding the collection of credit card debt. The only portion of the trial transcript filed by the appellant was from voir dire. That's the only part of the trial transcript that is part of the record for this court to review is that relating to voir dire. The juror questionnaires are not part of the record, and Ms. Fortin's answers to the juror questionnaire are not part of the record. As the court has already observed, the appellant filed a motion to interview juror, which was not sworn. She also filed a motion for a new trial, which was not sworn. Both of those post-trial motions were heard and argued by the trial court. Ultimately, the court entered an order on each of those post-trial motions, denying them. And one of the reasons why it was denied is because they were unsworn. The issue before this court is whether the trial court abused its discretion with regard to its prior rulings. However, the appellant only raised one issue by post-trial motions, that is whether there was juror misconduct. The appellant has improperly raised for the first time on appeal 3 additional issues, including whether the trial court erred in allowing the appellee to exercise 1 cause challenge and 1 peremptory strike, and whether the trial court erred when it denied the appellant's Larry Tennis motion for mistrial. Portions of the trial transcript, which would address the 3 additional issues raised for the first time on appeal, are not part of the record. This court as well as many other courts, have consistently held that in a civil litigant may not seek relief in an appellate court unless the litigant at least has raised the argument in a motion for new trial. Therefore, several of the arguments raised in the appellant's initial brief as well as their reply brief are raised improperly for the first time on appeal. But I will nevertheless address each one. The first issue.
Well, let me ask you this: is Mr. Gurley's motion for mistrial issue, is that properly preserved in your mind? About the asking
No, Your Honor. It was not properly brought before the trial court. It's raised for the very first time on appeal. I would argue.
So he didn't move for a mistrial he didn't move for a mistrial during the trial court proceedings?
I beg your pardon?
Did he not move for a mistrial at the trial court proceedings because the question was asked about whether the victim was on probation or not?
Well, we don't have the trial transcript, but we don't have the exact wording of the court's ruling. We don't have the exact ruling of the question. Honestly, I don't remember the question. I think that there is not any information upon which the court could rule definitively that the trial court abused its discretion in denying a ore tennis motion for mistrial. If I understand the allegations in the initial complaint, what is alleged is that on behalf of the appellee, I asked a question of a witness that was never answered. And furthermore, if I understand the allegations of the complaint, of the initial brief without the benefit of the transcript, it also alleges that the court gave a curative instruction on disregard whatever the jury thought the answer might be. Certainly, that is a proper way to address it, assuming that's the way that it happened in the trial without the benefit of a transcript. But I would argue that assuming that it was brought before the court properly, and that the trial court was allowed to even consider it at the motion for new trial stage, that the court still did not abuse its discretion if it gave a curative instruction. Your Honor, may I proceed?
Yes, sir.
Your Honor, the first issue relating to a juror named Austin, and that at the trial, Juror Austin was a school teacher at a private school who had work obligations during the time the trial was held. And so the issue was whether or not the appellee's challenge for cause for Juror Austin was proper. The court did not abuse its discretion in allowing just Juror Austin to be challenged for cause, because when the court questioned her, she said she had work obligations that would have and that she would have difficulty sitting fairly impartially. That's a typical cause challenge. I made the cause challenge to her, and the court did not abuse its discretion. That's the standard. Not abuse discretion in allowing Juror Austin to be challenged for cause. Another juror that was the subject of a peremptory challenge was Juror Horace. Again, this is not properly before the court. It was never raised in the motion for new trial. And there's certainly no record in the transcript that the appellee had a pattern of asserting peremptory challenges against all African-American jurors on the panel. And the court is mindful that the guidelines provided for this situation are laid out in Melbourne versus State by the Florida Supreme Court. And the trial court, when it was raised that juror Horace was in fact African-American in the record, the court inquired of the appellee as to the reason for the peremptory strike. The explanation was facially race neutral because Juror Horace, in fact, had 8 traffic citations by law enforcement agencies. So having heard the race neutral reason for the peremptory strike, the court did not abuse its discretion in allowing Juror Horace to be the subject of a peremptory strike. We have already talked about the Ori Tennis motion for mistrial. We'll just add to that argument that this court in 2005, in the case of DW versus Department of Children and Families, as well as the 4th District Court of Appeal in Lannon versus Foley, both cases cited within appellee's response answer brief. Both of those cases stand for the proposition that without a trial transcript, the court's rulings are presumed correct, citing the Florida Supreme Court case of Applegate versus Barnett Bank of Tallahassee, decided by the Florida Supreme Court in 1979. With regard to the motion to interview juror especially with Joan Fortin, it is important to note that when the Florida Supreme Court decided Baptist Hospital of Miami versus Mahler, it stated in no uncertain terms that an inquiry regarding interviewing a juror is never permissible unless the moving party has sworn the allegations. I think it's very significant that the Florida Supreme Court has said never permissible. So at the very outset, appellant's motion for interview of the juror was defective on its face for not complying with the minimum requirement mandated by the Florida Supreme Court, that is, that it be sworn. Furthermore, this court in Travelers Insurance Company versus Jackson in 1992 held in a case that where not only was the motion for new trial not sworn, but the motion to interview jurors was not sworn. In that case, this court reiterated Baptist Hospital's mandate. And in this case, not only was the motion to interview juror not sworn, but the motion for new trial was not sworn either. So the trial court, in fact, in its orders denying the motion to interview juror and the motion for new trial, cited as the very first reason for denial is that neither of the motions were sworn. Now, the court is mindful that when we're talking about interviewing a juror, the Florida Supreme Court has given us guidelines in the De La Rosa case, decided in 1995. In that De La Rosa case, there are 3 prongs that must be satisfied before a motion to interview juror is in fact to be granted. Now that's assuming, of course, that it's sworn to begin with, which was not the case in the case of Barr. So the greater weight of Florida jurisprudence holds that post-trial juror interviews are to be rarely granted, and the sanctity of the jury process, as well as the privacy rights of the jurors themselves, should be closely guarded and protected. And post-trial jury interviews are disfavored by the courts and are only allowed in very rare circumstances, and this is certainly not one of them. The first prong of the De La Rosa case was not met by the plaintiff. And the first prong relates to whether or not the information is relevant and material. In the first prong of this, the court considered all of the arguments made by the parties, as well as the written arguments, and appellee's arguments were the same then as they are now. The court, in fact, considered all of that, considered all the case law, and the trial court did not abuse its discretion in finding that the first prong of De La Rosa analysis was not met because the undisclosed information not only must be relevant, but it must also be material to the jury service in the case. We know that from the Roberts case decided by the Florida Supreme Court in 2002. De La Rosa did not dictate that all prior litigation history is per se material, and the test is not whether the information is relevant and material in general, but whether it is relevant material to the jury service in this case. And materiality must be analyzed on a case-by-case basis. We know from the Roberts case that the decision as to whether a juror's involvement in a particular prior legal matter is material should be primarily made at the trial level, because materiality is fact-intensive. It is there that the dynamics and the context of the entire trial process can be evaluated by the trial court. In this particular case, we must also remember that the Florida Supreme Court has told us that whether a particular prior litigation by a juror is material and relevant is also the subject of whether it is remote in time. And all of these prior cases allegedly involving this juror were all remote in time. And I've cited in appellee's answer brief cases where prior litigation history was in fact deemed to be too remote in time to be material. So the second prong of the De La Rosa analysis was not met either. Ms. Fortin answered every single question directly when she was asked the direct question, and there was no reason to believe that when she asked direct questions, she concealed anything. The third prong of the De La Rosa analysis was also not met. And I have cited case law where from the Third District Court of Appeal in 2013, where it was determined that an appellant's post-trial motion to interview a juror based upon post-trial research, which was something that could have been publicly and easily available at the time of the trial, was not obtained by the appellant until after an adverse verdict was received. Therefore, I believe, like in that case, as well as in this case, the third prong of the De La Rosa analysis was not, in fact, met because of a lack of diligence on the part of the appellant at the trial. In concluding, the trial court correctly ruled on the cause challenge of Juror Austin, correctly ruled on the appellant's objection to appellee's peremptory strike of Juror Horace, apparently incorrectly denied the appellant's oral tennis motion for mistrial, and correctly denied the appellant's motion to interview juror and motion for new trial because of juror misconduct. Those rulings were the correct application of applicable and controlling law, and in no instance did the trial court abuse its discretion in this case. Based upon the foregoing arguments supported by Florida law, the appellee, Orange County Sheriff's Department, requests that this court affirm the decision of the trial court in all respects. Thank you.
Okay. All right. Thank you, Mr. Palmer. All right, Mr. Gurley, you have, according to the clock, 6 minutes and 49 seconds to rebut. Go ahead, sir.
Your Honor, I'm going to stand for the most part on what has already been argued. However, the one thing that I would say and make note of is that appellee did not deny making the statements about asking the question about whether or not the decedent was on probation. And there is evidence in the record that a timely or tennis motion was made, because otherwise there wouldn't be a curative instruction given. So we can know from that, but if we could just narrow in on that, if the court feels that there's not enough information in the record, that narrow piece of the record can be produced, because I'm persuaded that it will show exactly what has been put into the initial brief. That
Mr. Gurley, yeah, that was raised in the answer brief, and you've had an opportunity after that brief was filed to have done so, and you didn't avail yourself of that opportunity.
Again, yes, sir, that is correct. However, I felt like there was enough in the record to establish what we already said, but hearing the concerns of the court as well as the further argument of the appellee, I'm just saying if that's the only thing that's is unclear, uncertain, or has not been provided in sufficient detail, that is just one way that it can be addressed. And I do understand what the court is saying. But again, I felt like there was sufficient record evidence that addressed that this motion was made timely, and that the court denied the motion for mistrial and instead offered a curative instruction to the court.
Well, let's assume it did happen, as you say, it then goes to apparently the question was asked, there was no answer, an objection was made. And what you're telling us is the trial court gave a curative instruction instead of granting a motion for mistrial on whatever issue, whatever argument you may have made in your Oritanis motion. You still then have to show us that one sliver, or that one question is, and the potential answer or how it was left with the jury so vitiates the fairness of the trial that, the mistrial needed to be granted, or saying it differently, you have to show us how the trial court abused its discretion in not evaluating the lay of the land at the time and deciding the curative instruction was the best route. I mean, tell us how you've done that, or how you've argued that here.
Well, I think all the facts of what this case was about and the context, and the fact that this instruction, this conversation with both parties was had just hours, if not minutes, before the court's clear instructions to the parties was ignored. And I don't think that under any circumstances that should be permitted and ultimately rewarded. And
so your recollection of events is that perhaps minutes before there was a discussion with the trial judge says you can't bring up anything about the victims being on probation, and armed with that ruling, I guess Mr. Palmer was the trial attorney. He went ahead and asked the specific question that the judge just minutes before said can't answer, can't ask.
Yeah, yes, and let me be fair to Mr. Palmer. It may have been hours, but it was, I believe, the same day, just before evidence was actually began in this trial. So it was clear. The judge's instruction was very clear. So how it affects the overall impact of whether the estate of Kenneth Aden received a fair trial, that is a totality of all the facts surrounding these kinds of, as I said earlier, Your Honors, these very difficult, near impossible cases to prove. Just if everything is done according to the rules of evidence and everything is done according to all the pre-trial rulings on motions in limine, it's still near impossible to persuade a jury that wrong was done, especially when it relates to law enforcement.
Well, I mean, you agree, though, that every violation of a motion in limine doesn't necessarily translate to a motion for mistrial having to be granted, right?
100%, Your Honor. However, in this case, again, looking at the specifics of everything that was involved in this case, I think that there was no way, once the bell was rung, there was no way to unring the bell. And that was that fatal and bitter seed that was planted in the minds of the jury that prejudiced them against the presentation of the evidence on the behalf of the appellant.
But if I understand what you're saying, there was not an answer given to the question that you say was improperly asked. Is that correct?
So, Judge, what I think the question was, and again, the record would speak for itself, and I understand everything that the court has said, and I agree with everything that the court has said, but I think the question was something to the effect that, isn't it true that at the time that this happened, Mr. Ayton was on probation? I mean, it's cross-examination. It was asked in the context of cross-examination. So yes, it was a statement that was made, actually. The question was posed in the form of a statement.
It was a leading question.
Yes, which
Okay.
I would do myself if there was no requirement not to probe in that particular area.
All right, you still have a
No.
minute to go.
No further rebuttal.
Okay. All right. Thank you, counsel. We'll take this matter under advisement and we'll be adjourned. Have a good day, counsel.
Thank you, sir.